It could be an up or down vote, but people may want to talk about it. So anybody that's got comments, fire away. Richard Orsinger.
Thank you, Chip. At the task force level, Chief Justice Sandy Marion of the Fourth Court of Appeals was very concerned about extensions or delays in the process, leaving inadequate time for the Court of Appeals to do its job. And it seems to me that the 20 days, which probably now should be 30 days, should say 30 days plus extensions. If you don't, then you're kind of pitting the Court of Appeals deadline against the court reporter's deadline, and it's really unnecessary. So it would seem to me to be most advisable that this deadline under Rule 6.2a is told for no more than 30 days plus extensions granted to the lower court or something of that nature. Thank you.
Great. Thanks, Richard. Any other comments? Bill, what do you think about moving it from 20 to 30 days plus extensions, plus any extensions?
Personally, I think that is an appropriate, that extending the 180-day deadline or tolling it is an appropriate step to take, so that time needed to develop these claims is not counting against the Court of Appeals, or otherwise putting the Court of Appeals in a difficult position.
Okay. Richard, is that your hand up from before, or is it renewed?
I apologize, Chip. I forgot to take it down.
That's all right. Justice Christopher.
I would not put in the extension language. I would just say the 30 days. That will give everyone incentives to keep going. So I would just say 30 days, not and not add extensions. Like if the court reporter is late, the case can still move forward with briefing. And that hopefully is the only delay we would have on the matter. So.
Thank you, Justice Gray.
This is kind of one of those things that is outside our bailiwick, but we may want to check to see before we write it into a rule whether OCA's programming on this actually will allow it to be told in the way we think it's going to be told. But that's an offline kind of thing that needs to be checked before we put it into the rule.
Okay.
It's an odd thing the way they do it. Unlike all the other performance measures, this is a 180 days. It's not the end of the month in which the 180 days runs. It really is odd, because if you issue the opinion on the 181st day, it's late. Even if there were 15 days left in the month, unlike all of the other performance measures. So
okay. Anybody else have any comments about the tolling under 6.2a, 30 days? All right. Is there any opposition to having this 30-day period tolling? Anybody against it? If you are, speak now. Okay, nobody against it, Bill. So I think we can move on from this. Is there any other issues? Are there any other issues relating to this Rule 28.4D that we need to talk about?
No, that covers everything for today. The subcommittee's next task will be to move on to subsequent parts of this involving Andrew's brief procedures and so on and so forth. But that's the discussion for a future meeting.
And do you want that at the next meeting, or do you want to skip a meeting?
I'll respectfully move for an extension of time until the meeting after next.
All right. You've been working hard. The extension's granted. I'm just making a note of that. All right. Great. Well, now, remote proceedings rules, proposed changes to TRCP 21D, 500.2G, TRCP 118C, TRCP 18C, 21, 176, and 500.8, and trap rules 14, 39, 59, and judicial administration rule 12. No hill for a climber, with Kenan, Lisa, Tracy, Christopher, and a guest speaker, that being Quentin Smith. I don't know if Quentin is here or not, but if he is, we'll be happy to hear from him. And Kenan, you may not have been here at the start of our meeting, where I mentioned a call from Senator Hughes conveying to me both his and Senator Huffman's concerns about modifying rules relating to remote proceedings in light of the fact that the Senate had not agreed to a House bill that did some of the same things that we're talking about. So with that, Kenan, are you leading, or is Lisa leading this, or who?
Can I start out, Chip?
Certainly.
Okay. So I just want to give everyone a little bit of background about our task force. And what we did last year during the legislative session was to identify statutes and rules that might need to be changed to accommodate for remote proceedings. As the senators said, there was some statutory language passed by the House, but it failed in the Senate. Judge Miskell, Judge Roy Ferguson on our task force worked a lot with the legislature on this issue. And if it's all right with you, I'm going to let Judge Miskell talk a little bit about what some of the concerns were. Primarily, I think, and I might be stepping on your toes, but primarily, I think there was a lot of concern about in the criminal arena. And, that is not in these proposed rule changes. These are all with respect to civil proceedings. So I think that will allay a lot of their fears about our proposed rule. But if I could get Judge Miskell to say a little bit about what went on in the legislative session, just so that the committee has some background.
Sure. And I have not talked to Senator Hughes specifically about this, but I've talked to several senators and other people that were involved and all that. So I'm not going to put names to any of it, but I'll just give you kind of the highlights of the things that I heard most often as concerns. So number one is just sort of an icky feeling about it. So I would categorize that as the dignity of the court or tradition, or it just seems wrong, right? And so you ask for follow-up and, well, what are you concerned about? Well, it just feels wrong. Okay, so that's one thing. And I don't mean to minimize that. I heard that a lot, actually. Secondly, some of the legislators who are lawyers, who are civil lawyers, just don't like it because they think they do better in the courtroom. Thirdly, I actually heard from several people that these judges just need to get back to work. So there's a belief that if you're not forcing your judges to show, well, and again, our current system doesn't actually force our judges to show up in person, by the way, but there's a sense that if you prohibit remote hearings, you will make your judges work harder because they will have to come in person, and that means they're doing something. One thing I heard, so for redistricting, the legislature held some committee hearings online and took public comment virtually for some of those. And what they experienced was a lot of people showing up to read the same script, and the sense that those people would not have put forth the effort to show up in person. And so there was a concern that if our courts and other government functions are allowed to be done on Zoom, that there will be more participation from low effort folks that don't really have skin in the game or clog the system. And then I will say the final thing I just heard over and over again was jury trials. And so again, I think when I looked at our civil trial numbers, I think 0.6% of civil cases are resolved by a jury trial. So if that's the thing that bothers everyone the most, I think we can focus our efforts on the 99.4% other cases that are not resolved by jury trials. So anyway, I'll just conclude the summary there, but that's generally the categories of responses I heard from legislators and other folks that were anti court hearings by Zoom.
So after the legislation failed, the Supreme Court asked our task force to proceed forward with respect to changes to the rules of civil procedure to accommodate remote proceedings. And so that's what we did. We had a lot of input from members of the bar. We had input from the State Bar Rules Committee as well. I think Cynthia was on the Zoom earlier. And we had members from the State Bar Rules Committee come and weigh in on some of these rules also. So we are not dealing with trials, jury trials at all. The only thing that could possibly affect a jury trial is whether or not the judge allows a witness to appear remotely in a jury trial. One of our rules would allow a witness to appear remotely in a hearing or trial. Most of us that were trial judges, especially civil trial judges, where you had to sit through depositions of doctors or depositions of somebody, would much prefer to have those witnesses appear remotely than to have to sit and listen to a deposition. So, I mean, when you think about, well, what's a remote proceeding? I mean, depositions are essentially remote proceedings that then get played in a trial. So I think people shouldn't be afraid of some of these changes that we're hoping to have made. So with that, I'm going to ask Kenan to take over, because even though she's subcommittee 2 on our report, we think it would be better for her to start and kind of lay the groundwork for those rules. Then we'll move to Lisa Hobbs to do those rules. And finally, we'll get to Quentin on subpoenas. So Quentin knows he might be here for a while. We'll start with Kenan.
Thank you
All right,
so
Kenny,
much.
thanks.
Thank you so much, Chief Justice Christopher. And before I get into the substance of my explanation of the work of Subcommittee 2, I did want to share with the full Supreme Court Advisory Committee that the State Bar Board of Directors recently issued a resolution that I have included in the chat box in support of work being done in regard to remote proceedings. And in the conversation at the State Bar Board level, there was some discussion about how this will impact people who want to continue to appear in person for various proceedings, including trials. Ultimately, the resolution that came from the State Bar Board of Directors is not focused on the substance of the recommendations of the Remote Proceedings Task Force, but instead on the work being done in regard to rules pertaining to remote proceedings, and just more generally rules that might need to be amended to remove impediments to remote proceedings. In that regard, for the record, I will read the portion of the resolution that is in fact the resolution. It states, therefore, be it resolved that the Board of Directors of the State Bar of Texas supports the efforts of the Supreme Court of Texas and the task force to remove impediments to remote proceedings, and supports the Supreme Court of Texas adopting and implementing rule amendments removing impediments to remote proceedings. So with that backdrop in mind, I'll go to the subcommittee's memo that's included in the materials for today's meeting. I believe it begins on page 39 of the PDF if you're reviewing things electronically. In the memo from the subcommittee, there is an explanation, if you will, of the flow of work at the subcommittee level. In addition, just to put some context around the work that we've done, we've included some background information. For example, Exhibit 1 to the memo is a letter from Chief Justice Heck dated September 2nd, 2021 to Chief Justice Christopher with the request that the task force begin drafting rule amendments to remove impediments to and support the use of remote proceedings, starting with the Texas Rules of Civil Procedure. Exhibit 2 to the memo, again, just to give you all context and background information, is from Chief Justice Christopher, the chair of the task force, where she laid out the subcommittee assignments that she referenced earlier today. Exhibit 3 to the memo is proposed amendments to Texas Rules of Civil Procedure for the civil and district courts. And Exhibit 4 to the memo is the proposed amendments to Texas Rules of Civil Procedure relating to justice courts. So just pulling back a little bit and giving you all some additional background information. The way we did things at our subcommittee was to go ahead at the forefront and work with members of the Justice Court Working Group. That entity was also tasked with looking at rule amendments specifically for the justice courts, but because there was quite a bit of overlap in substance, the head of that working group, Judge Nick Chu, and I decided that we would combine our groups at the forefront because we thought that that would lead to a more thoughtful process and perhaps less disagreement at the end of the day in regard to the substance of the proposals. So as you'll see in the memo that I've been referencing, I've laid out all of the members of the drafting team, which I've referred to as the combined team, and also mentioned the participation of a member of the State Bar Court Rules Committee, Chad Baruch, at the prompting of Cindy Timms. As Chief Justice Christopher mentioned earlier, Cindy Timms got together with the leadership team and got involvement of the the State Bar Court Rules Committee. So that combined team did work on these proposals, and I think it's important to give everyone credit who participated in the process. And to that end, the third paragraph of the memo identifies all members of the drafting team. Some big picture points as laid out starting on page 2 of the memo is that we had a robust discussion about whether the trial court judges or the participants should be able to determine whether a proceeding is conducted remotely or in person. And at the end of the day, at Judge Miskell's good suggestion, we thought, why don't we follow the approach taken in the emergency orders that have been working throughout the pandemic? And this was great because normally you're drafting rules and you're wondering how might this work in the real world, but we have, if you will, a pilot program that's been operating successfully for a long time through these emergency orders and how court proceedings have been conducted during the pandemic, including remotely. So the language that you see in the proposed rules in exhibits 3 and 4 is really kind of, if you will, building off of the language that's been in the emergency orders from the Supreme Court of Texas. And that is to give the trial courts discretion to require or allow proceedings to be conducted remotely or in person. However, there's also recognition that there's no one-size-fits-all approach for any court proceeding. So the rules lay out a procedure for objecting to the court's chosen method of appearance and providing good cause for that objection. As explained in the memo, we have some examples of good cause in proposed comments to the proposed rules. The approach there is akin to what's been done for good cause examples in the context of expedited proceedings, with this court, the Texas Supreme Court, having a history of laying out examples of what good cause may be in comments to the rules. I think it's important to note that the good cause examples are just that, they're examples. It's intentionally not exhaustive in the explanation in the comment. Another thing that I should point out about the rules, particularly in light of what I heard at the beginning of the meeting, and then again from Chip about legislative interest, there was acknowledgement at the drafting level that there are statutes in place that may not allow certain proceedings to be conducted remotely. And so in the rules as proposed, you'll see that after the statement regarding what a court can do in terms of requiring or allowing the proceedings to be conducted remotely or in person, there's recognition that if statutes explicitly provide otherwise, that the proceeding might have to be conducted in person. So recognition again there that the legislators may have chosen certain proceedings to be conducted in person alone. In that case, the rule would not give the trial court discretion to have a remote proceeding. Another thing that we talked about a lot at the combined team level was how we need to give notice of court proceedings, not just remote proceedings, but also in-person proceedings, and whether there should be some additional meat put on the bones, if you will, of what's in the rule now, specifically Rule 21B of the Texas Rules of Civil Procedure. And you'll see in the proposed amendments to that rule that there is now some language about what a notice must contain, specifically must contain all information needed to participate in the proceeding. And then there's a non-exhaustive list of what that might be. Specifically, it states that the notice now has to include the location of the proceeding or instructions for joining the proceeding remotely, the court's designated contact information, and instructions for submitting evidence to be considered in the proceeding. I think it's important to also point out that the proposed comment to that amended rule makes clear that the court should post or otherwise provide the information needed for notices of proceedings. I think we've probably all seen different courts have different ways of going about these notices for remote proceedings and probably notices for in-person as well. By way of example, in Travis County District Courts, there is a very specific sample notice for remote hearings. And I don't think that's in place in every single county, but to the extent that courts have specific preferences and also just feel like people should be doing certain things in the notices or stating certain things in the notices, there's encouragement that additional guidance beyond what's in the text of the rule proper be provided by the courts. Another thing that I should say at the forefront is that in figuring out what examples of good cause for getting out of a particular type of proceeding, whether it be remote or in person, and figuring out which types of examples to include, I want to tip my hat, if you will, to the people from the Texas Access to Justice Commission who participated in these discussions, because you'll see that one of the examples of good cause is about people being unable to get the language access services they need. Additional examples are the inability to appear remotely, perhaps because you don't have the technology that you need or don't have the proficiency in that technology that's required. And then for good cause of not coming in person, one example is that being there in person might compromise health or safety. I think the final thing to just point out so people are aware of it, the Justice Court rules that are provided in Exhibit 4 largely track the proposed rules for district courts and county courts laid out in Exhibit 3. There are just a few exceptions, and I'll go over those very quickly. One, in the justice rule, there are definitions for a lot of things that we don't see definitions for in the other rules. And in keeping with the tradition of providing definitions, there is a proposed definition of court proceeding in Exhibit 4 that you'll see. In addition, I believe from what I've heard and then what was reported in the memo, there was a thought that some additional content would be helpful in terms of communication with parties involved in justice court proceedings, in part because a lot of these individuals have never had any prior contact with the court and may need a little bit more guidance, if you will, than in some other settings. And so there are, like I said, just a few variations between these two sets of rules, but primarily they're very similar in nature. With that explanation, I will turn it over, if it's okay, to Judge Miskell to fill any gaps that I may have left inadvertently, because she was certainly an integral part of the team and a co-drafter, and I want to give her an opportunity to speak to these proposals, if that's okay, before we open the floor.
Absolutely. Go ahead, Judge.
Sure. I just wanted to circle back that the bulk of our time as a subcommittee was spent trying to figure out how do you define a remote hearing. And I was the stick in the mud on all that, because every time someone came up with a good idea, I was like, well, what if only the court reporter's remote? Or what if, one side has an attorney remote, but everyone else is in person? And so, Thanks to the committee for putting up with my relentless counterexamples. But what we ended up going with was just talking about remote appearance, right? Because the judge might be remote, or the court reporter might be remote, or the language interpreter might be remote, or everyone else might be in person, or some combination. And so it's sort of very difficult to define what a remote proceeding is, much more streamlined to define what a remote appearance is. I will say my big concern about this is, for 100 years, more than 100 years, courts have had the discretion, and it's the judge's decision, to allow anyone to participate by telephone. And it's always been the case that someone can ask for it, that someone can object to it, but at the end of the day, the judge can allow anyone to appear by telephone, could allow a witness to appear by telephone in a jury trial. I mean, so we've had this flexibility for telephone appearances for 100 years, and I don't want to do something in our rules and in our interfacing with the legislature where now, since we're talking about remote appearance, it all gets banned and a power that we already have is taken away. So as we look at these rules, just please be conscientious of let's not throw any babies out with any bathwater, and remember that we have been, as Tracy Christopher said, doing things via remote stuff for a long time. So that's all I need to add, really, and we can get to the discussion.
And if I may, I'll just tack on and say that part of what we were considering at the subcommittee level is the information we've received indicating that participation in court proceedings has gone up when they've been conducted remotely. And what does that tell us? It suggests there's been an increase of access to justice. And I think that's a laudable goal. In regard to the comments made about additional people come to these legislative processes and they're not prepared and they're not giving us anything new, this is a completely different setting, right? This is about whether participants in litigation and other proceedings are actively engaged with it, are getting meaningful access to the justice courts, to the civil district courts, county courts, et cetera. So I think that increased participation is a very good thing in court proceedings. And the final thing I should say, just to ensure that there's no confusion going forward, I think the way the rule is written, it could include juries. It does not speak solely to hearings. And so that is something that I want people to be aware of when we have these conversations, because I think the way it's written, like I said, it's not limited to hearings alone.
Yeah, Robert's got his hand up, but I wanted to ask Judge Miskell a question. No doubt that the judges have had the authority to allow telephone hearings, telephone depositions, or all sorts of things. How often is that used in your experience?
So prior to the pandemic, it was used not infrequently. I mean, somebody would be out of state or somebody had a conflict or whatever. We didn't like to use it because you lose a lot of information to have something be telephonic instead of video. And the solutions for having video weren't easy before the pandemic. So technically I had court call available, but it cost $90 and the parties had to set it up in advance. So I couldn't use court call for anyone that didn't have $90, which is a lot of my docket. So pre-pandemic, video was just functionally hard to do. And then we didn't prefer to have anyone testify telephonically because we'd always rather them be in person so we can see them. But I think that with the increased ease of the video solutions we have now, a lot of times video is just as good as in person for certain types of people, be that a witness or the court reporter. Like, for example, my court reporter had COVID and was out for 2 weeks. And when we're finding court reporters now, there's a shortage, but we can get court reporters from outside our area, which was the only way we were able to keep going. So we not infrequently used telephonic appearances. I think it was artificially low because given the choice, I was like, no, I don't want to just listen to a disembodied voice for an hour or what it is. You know, they need to come in person. But now that I can do video, I'm happy to have them testify by video for an hour. It's fine.
Yeah, court. Tell everybody a little bit about court call. My understanding is, I know in California it's been used for at least 15, maybe more years, And in California, many hearings pre-pandemic were done by court call. But as you say, it's not video, but it allows.
Court call does video, yes.
Yeah, but in California, they rarely do video. It's almost always telephonic.
Yeah,
but
so I wouldn't use
what is
court call
court
for
call?
just telephonic because I have the ability to do conference calls directly from my bench. So there's no reason to pay a third party to, under our technology, do a telephone call. What court call would do is they, before the pandemic, set me up with a webcam. And then when you make a reservation through court call, they actually have an in-person operator sitting there, making sure everyone's connected, moving people to where they need to be moved. Now with Zoom, effectively, I do that, right? So we don't need to pay court calls operator $90. We have someone on the court team doing it. But when I used court call, it was video, but it was really limited to the people that can afford video and know how to set it up in advance. Whereas with the solutions we have now, like Zoom, you don't have to worry that there's a cost to set it up, and it's easy enough that almost everybody can figure it out with some help from me.
Yeah, but court call is a third-party vendor, right?
Correct, yes.
And it's been around for how long, 15, 20 years, or do you know?
I don't know. I mean, we used it in my court as far back as 2015, and that's all the experience I have, so.
Okay. I've had experience with it for at least 15 years, maybe longer. Not in Texas so much, but in other states. And some people will say that this remote, even though you had the power, it was rarely used. And that may be true from jurisdiction to jurisdiction. But there are some places where it's been done a lot for a long period of time.
Oh yeah, absolutely. When the court call came and did their sales pitch, there's jurisdictions where they do whole dockets, similar to what we did during the pandemic, half day court dockets, hundreds of participants on court call or whatever it might be. So very similar to what we were doing. The only reason it wasn't as widely used as Zoom is because it wasn't as easy. There was a lot of friction in setting it up and using it. And Zoom is essentially the same thing with much less friction and cost. And so it ends up getting used more.
Yeah, thanks, Judge. Sorry, Robert, didn't mean to jump the line on you. You've got the floor.
So I wanted to comment and express some really deep reservations about what I think are two things. One is both the rush to pursue rule changes of such a significant nature, literally while we're in the middle of the pandemic. And secondly, in terms of the overall kind of suggestion that the rule changes would make, which would be that there's no preference to either a in-person or remote hearing based upon the way the task force presented the proposed rule. And like, as Kenna noted, of a significant concern that it would, at least as drafted, cover jury trials as well as non-jury trials and evidentiary proceedings. The challenge that we're facing is obviously we're in the middle of a dynamic, which is an exigency that has caused significant disruption and has certainly validated the value of having remote proceedings to be able to continue to have our justice system function. And it certainly has functioned well in that respect. But that doesn't mean it's the optimal approach and the approach that should be the default. As we've noted a couple of times, it's been our preference as a committee to meet in person, and that's what we hope to get back to. And similarly, being in court, being in person, sitting, standing before a judge, having their undivided attentions, having witnesses there before the judge whose credibility can be determined, making sure that you're seeing their environment, that they're there and understanding the importance and the significance of the legal proceeding are important. And the idea that we would simply choose to go remote, and some judges based upon the rule would have the choice of having all their proceedings remote, again, I don't think is the optimal way that we should proceed. Another issue is that we are literally in the middle of an experiment. We have been working this dynamic for now just under 2 years. And obviously the prevalence of Zoom as a feature or remote proceedings is even less experienced. And there are significant lessons are being learned and will be learned. And Kenna made a note about participation being up. That's an anecdote. It very well might be true, but we don't know whether it's true. We don't know what the impacts are. We don't know about how well depositions are functioning remotely versus the model of having all the parties being there. There's certainly pluses and minuses, but I think we should be very reluctant to make a significant rule change while we're still trying to understand the impact and the consequence of doing things remotely. And I know that studies are being conducted and people are looking at it, trying to understand what the impacts have been and will be, what are some of the disadvantages that might be addressed, both types of proceedings, but particularly in having remote proceedings. And I think Judge Miskell pointed out that she's gotten a lot of objections, and I really think they shouldn't be minimized. They're very significant, particularly from people that have practiced for many years in courts and question jurors, question witnesses, and been able to cross-examine them, and the dynamic's very different. And I think they are understandably concerned about the changes that the rule would make. And the issues also, the types of issues in the rule itself is proposed. Again, as I pointed out, the rule does not give any preference to remote or in-person, which I think that alone is a problem. And then it provides a basis for good cause, but without any indication of what could constitute good cause. For example, does my right to cross-examine a witness in front of the witness constitute good cause? I think there arguably is a fundamental right to do that, to confront your witnesses, to question them. But is that good cause? Is the fact that that's my preference enough, or does the judge have full discretion to minimize that if the judge doesn't want to be there? There are a number of other issues, and I'll defer on that till maybe we get further on, about issues about notice and the ability to basically subpoena a witness from anywhere in the state without regard to the 150-mile rule, even though that still can present significant issues, particularly when the witness might want to have their lawyer present with them for a deposition or to appear at trial. Many issues that I think we are really not fully understanding as we press forward, and I think rush forward to talk about a major rule change.
Thanks, Robert. John, I'll get to you in 2 seconds for the question for Robert. It goes without saying, but I'm going to say it for the sake of the record. We're all here in our individual capacities, providing our views to the court. But it's no secret we all work, most of us work for others. And do you have a sense, Robert, I know you're just speaking for yourself, but whether starting with your very large company that consumes many legal services, going all the way into other big businesses, do you think they share your thoughts that we ought to go slowly on this, or you don't have any data on that?
I am actually seeking more data on that, but yes, initially when these issues first came up, we have had some concerns as an entity about being forced to proceed remotely. We've had some experience with it in trials and arbitrations, as well as in court proceedings. And I will point out, while some of the concerns haven't been fully realized, we still remain very wary and concerned that our rights as a litigant are going to be altered by the push to go remotely. And I think we've got a lot of trepidation about that. But I will point out that the comment that I made earlier was based upon my personal perspective, and I appreciate your noting that.
Yeah, well, I mean, it goes without saying, but this is a pretty big issue. And do you have any sense, I know you're going to look at it, but any sense of whether other large corporations who are in the justice system a lot have similar views?
We've had discussions in organizations that I'm a part of that we've started to see other dynamics in other states, and that similar concerns have been raised. Some companies are probably a little bit more comfortable with it than others, but we are concerned about the impact that it will have on the prior process, the in-person process, and the impact that it might have on the rights of some of the litigants.
Okay, great. Thanks so much, Robert. And John, I'm sorry to hop over you, but I wanted to ask Robert those questions while I had it, fresh in mind. So the floor is yours now, John.
Okay, thank you, Chip. For the record, I want to go on record as saying I am all in favor of virtual processes as of 3 years ago, but I agree with everything that Robert has said, and I also agree with everything that just Judge Miskell have said. I see in the chat that Alex Albright has said that Dallas County uses court call. It's clunkier than Zoom, in my opinion. He's absolutely right. Dallas, we rolled out. I actually purchased the court call licenses and the kiosk, and we're using them primarily in our criminal courts. Actually, for our criminal courts, but that we have used the kiosk in our jails. That's how we're able to maintain the low jail population. The advantage of using court call is that it gives you the ability to do virtual proceedings as well as sign in documents. The problem is what we had when we rolled this out, just as the pandemic was getting the hit. And we didn't have an opportunity to vet the process fully. That said, we've taken a lot of lessons learned from the rollout of our court call kiosk and the licenses. I'm actually in the process of purchasing, I think, 20 more licenses for our judges to use on the bench. I think that's necessary for where courts will be, not in 2022. I doubt very seriously in 2023, but in 2024. I believe the approach should be is that we have participants who actually vet the process so that we have a template of how virtual court proceedings and even virtual trials should proceed going forward when that is necessary. We also have to take in consideration that we don't want to exclude those who don't have access to internet or any type of virtual technology. So I think while everything that we're saying is absolutely correct, some I'm in favor of, some that I'm not in favor of, that I'm not in favor of is because there is no history for us. There's no data there for us to use. And so I think we should look at, so in essence, we should slow this down, look at what it takes to actually be effective in rolling out remote proceedings so that we are doing it the right way, so that all the questions, whether it's from members of the legislature who are attorneys who still practice law, and so that we are making rules so that those proceedings are actually more effective than not. And so I think the best approach is to have a group who's actually working with, whether it's a software provider, we could use court call, or we can use, I've also purchased collaboration units for our probate courts who didn't have any technology in their courts at all. And the collaboration unit is basically a 90-inch computer with webcam, so that and it also has the ability for the judges to sign documents. And so I think there should be a collaboration between at the local level with the clerks, the judges, and with some vendors, so that we can actually formulate what it takes, what is a virtual process and what it should be, so that we document all of those steps as in best practices, lessons learned from the pandemic. as well as everything technology, what technology is available to us, so that we can, in the most knowledgeable way, approach virtual processes.
Great, thank you so much, John. Richard Munzinger.
I want to join Robert's cautionary words to everybody. We have to remember that the rules that we propose and that the court ultimately adopts are rules that are designed to facilitate justice. And justice is based upon truth. How can a judge conduct a non-jury trial remotely and make a fair, honest judgment regarding the credibility of the witness? I go back to the first case I ever tried. I was a young lawyer. I got out, got my license. A partner came in, handed me a file and said, go try this case and try it non-jury. And it was a collection case. What didn't involve much, but I went and I tried the case in front of a judge who I later learned was probably one of the best judges I ever worked in front of in my life, George Rodriguez Sr. He was as fair and as good a judge as I ever worked in front of my life. But in this case, he sat on the bench and the witness sat below him to his left. I look at the judges who are speaking today and I look in their courtrooms and I see where the witnesses sit generally below and to the side of the judge who doesn't have a look at their face. How can you make a judgment regarding the credibility of a witness without looking them in the eyes and the face when they testify? You really can't. You can't judge their demeanor. Can you be certain that someone isn't whispering or shoving papers to them or something else? Bear in mind, the rules that we are adopting are based on justice. People, the rights that are litigated in court don't come from government. They don't come from anybody. They come from God, according to our system. We hold these truths to be self-evident. This is where our rights come from. So when we adopt these rules that we're adopting, so often it's done in the name of efficiency. We're clearing dockets. We're accomplishing results. We're moving. We're doing what we're supposed to be doing. Robert's point about doing this in the pandemic and in the middle of a pandemic is correct, in my opinion. This is an unusual time, unprecedented in my 83 years. I practiced law 56 years. I'd never seen anything like this in my life. We haven't had a jury trial in El Paso. Well, that's not true. We have had jury trials. But we were told the other day, we won't have any jury trials, most probably in 2022. We haven't had, how many people are languishing in jails? How many contracts, what problems are there? And so we're going to hurry up and make rules to accommodate this situation. I don't want to take too much more time. I just want to say to everybody, it's one thing to resolve a motion for continuance, a motion in limine, or whatever a motion might be remotely, because the concepts and the law and the cases and what have you can be argued. It is a totally different thing to resolve somebody's rights based upon sworn testimony in a non-jury trial. And a jury trial, to believe that you could conduct a jury trial remotely, good God, I've got a bridge all of a sudden. Are you kidding me? Are you kidding me? You're going to have 12 laypersons who are sitting there watching television, 6 of them mothers with 2-year-old children who are tugging at their arms and hands, and they're going to decide my case, my rights, my sacred honor, my fortune. That's crazy. That's literally crazy. And we need to be very careful about adopting rules that do not make the distinctions between resolving factual issues and having judges hear motions and what have you. I'll be quiet except to just say, boy, we need to be very, very, very careful about what we do here. To go back to that trial I tried as a young man, that judge ruled against me. Had he watched that witness testify in front of him, the defendant in the case, he would have known at once this fellow was lying. It was so patently apparent to everybody in the courtroom. The judge couldn't see him, couldn't see his face. And these are problems. These are the realities of trials. We have appellate rules. Well, the judge made the decision regarding who he was going to believe or who she was going to believe. And so we have to respect that finding. It was the judge who heard the testimony. Well, did the judge really hear the testimony, or did the judge look at a TV set? We need to be really careful and remember what we are doing here. This is a republic in which the citizens have the rights. They don't work, live to serve the government. They're supposed to be free and do the things that they do. And when you take their rights away from them, this is not something that should be done quickly or heedlessly. Thank you.
Yeah, thanks, Richard. I did not realize that bridge in Brooklyn was for sale, but let's talk after this meeting, okay?
Okay.
Tom Riney. Yeah, I'm sure it's very eloquent, Tom, but you got to unmute yourself.
Thank you, Chip. First of all, let me say I recognize that we've had to do things during the pandemic, and it's been difficult for the courts. And I applaud the efforts that they have, and also to the people that were on the committees and the subcommittees. You were given a charge. I know you did a lot of work. But what this rule proposes is a fundamental change in our civil justice system, and we need to recognize that. To use a currently popular adjective, it's transformational. And I'm grateful that you all talked to the Commission on Access to Justice. But I think we need to go way beyond that if we're going to make fundamental changes to our civil justice system. We need to talk to the Texas Trial Lawyers Association. We need to talk to the Texas Association Defense Council. We need to talk to Tex Aboda. We need to talk to the American College of Trial Lawyers. This committee has had representatives of the American College come and speak to us before about things. The American College has put out position statements on interim measures for virtual court proceedings. That should be consulted. The National Institutes of Trial Advocacy has put out a paper strongly condemning taking away the rights to in-person court proceedings. We need to talk to the litigation section of the State Bar. All of those types of and other similar organizations need to be consulted before we make this type of a dramatic change. Now, I didn't hear Chip mention the comment about Senator Hughes this morning because I was on a Zoom hearing on a motion for summary judgment, which was fine. I don't know that it would be appropriate in every summary judgment motion if it's real complicated, but it was fine. Nobody objected. That was fine. I participated in numerous depositions by Zoom. Some are appropriate, some were totally inappropriate and unsuccessful. I have not participated in a jury trial by Zoom, but I have, just out of interest as a trial lawyer, kind of kept track of some of the articles about that over the last year or so. Here's one headline: Zoom jury trials, an idea that vastly exceeds the technology. Another headline: potential jurors exercised on elliptical trainers curled up on bed during virtual voir dire. Others talk about jurors that were sleeping, that were involved in other activities. That leads me to a comment about some of the criticisms that have been made about resistance to moving away from in-person proceedings. And again, I'm not against them at all times, but before we make this huge jump, let's consider some of those. A statement was made about there were some icky feelings and had to do with dignity of the court. I think we ought not to put dignity of the courtroom in the same category as icky. Let me explain. I've tried a lot of cases, and most of the time, if I have the opportunity and my client or an important witness has not testified in a courtroom before, I take them over to the courtroom, put them in the witness chair, and go through some things. And without exception, that witness client will say, I am so glad we did that because that's not the situation I'm used to being in. because our courtrooms are built with the judge up higher. That's for a reason. It's to show the respect that we give the judge and the judge's role. The courtrooms are built, they are dignified for a reason. And people are going to behave differently. They're not going to be vaping. They're not going to be curling up to take a nap, because that's not the atmosphere that a courtroom fosters. So before we're willing to throw that out, we need to think, what is a trial like if everything is virtual? And I would suggest to you that at least as far as jury trials are concerned, the record is not very good very far. The argument is made, well, only less than 1% of cases are resolved by jury trials. I expect that's probably true. But the other civil cases that are filed, take a look at what's likely going to happen in a jury trial and what those results are in determining how the case should be resolved, either by settlement discussions, by mediation, or perhaps some other circumstances. I don't want to get into details, but the statement was made to civil trial lawyers. Well, some of them just say, well, I can do better in a courtroom. I'm one of them that says that, but it makes no difference whether I care if I do a better job or not. But it can make a difference to my client. And my client and your clients each have the right to be effectively represented. You know, Rule 1 of our civil procedure rule says the proper objective of rules of civil procedure is to obtain a just, fair, equitable, and impartial adjudication of the rights of litigants under established principles of substantive law. Now, I don't think this particular rule, moving to remote proceedings, meets what that rule commands us to do with the rules of civil procedure. I agree with almost everything that has been said about urging us to move slowly. And I think we need to really get a lot more people involved and really understand from people who are in the pits, in the trenches, what the impact of such a rule would be.
Tom, I can't help but wonder if you would answer a question. Do you think this is a generational thing with millennials like Justice Christopher and Kennan on the side of using more remote type access, and then old guys like you and me and Munzinger resisting it?
You know, I thought a lot about that, Chip, as I was thinking about this meeting, because I don't want to be that way. Well, we've always done it this way. That's the way that it should be done. But a lot of what we do in the courtroom is developed slowly, and it's developed because we found that it's being effective to meet these objectives that we have. So I'm not against change. I've already said I don't mind. By the way, I think anytime parties want to do it by agreement, I think it probably should be allowed. But it's when it's left to the discretion of the judge, which leads me to another point, Chip, and I certainly don't mean this with respect to any of the judges on this committee, but any of us can just pick up an article at any time and talk and read about the disappearing jury trial. Yes, we have statistics show there's very few cases going to jury trials. What is the impact of that? If we're having a hard time getting young lawyers to get significant jury experience, that means that we've got a lot of people coming on the bench who don't have a lot of experience with jury trials. And yet we're going to give them the discretion as to whether or not there's, quote, good cause to allow a jury trial or not. So in answer to your question, I think we have to think about that. Is it just resistance to change, or are we giving up some practices that have been based upon many, many years of experience and have some validity to them? Can they be changed? Yes, of course. Some probably should, but I urge caution.
Thanks, Tom. Judge Mendoza.
So there's been a lot said. I just want to share my perspective as a trial judge is that this is exhausting. Zoom is exhausting. Even this meeting for this length of time is much more tiring than had we been in person, right? If we're in person, we can look around, we can move, and I don't know how close you are to your computer, but I'm pretty close. And so I would like to think that I'm with the millennials, but perhaps I'm with the older crowd because because I think that there's some issues with Zoom. My concerns are the following: that implicit in some of the criticisms of remote proceedings is that somehow the judge isn't there, or the judge is calling it in. And I have to tell you that remote proceedings are not easy, and we're working. We're just at a different place, and it is not easier. For especially in the civil proceedings, how many of you heard that if the judge isn't in the courtroom, nothing's going on? The civil docket is slower, and you're not on the bench that much. And I always took issue with that criticism. I have a criminal docket, so yeah, I'm on the bench a lot, but that didn't mean I was working any more than the courts that only had civil dockets. And so, I take issue with those criticisms of trial judges that were not working, that were calling it in, that we want to do remote because it's somehow easier. I don't think it is. I also think we had some, we've had some limitations. We're talking about remote proceedings in civil cases, but everyone can see and argues, right, that it's going to slide into the criminal realm and that it's going to slide into jury trial. So even if we take it out, that's going to be the concern, and that's what people are going to, assume it is going to happen. But I think that's one good way, that if we could be clear about the fact that it's not for jury trials. And then let me say that I am opposed to a justice system that's different for civil cases and criminal cases. I think either it's just or it's not just, and so I think it should be the same. So having said that would be one way to be clear. The other thing that I think that Justice Miskell mentioned is that judges always had the ability to hold hearings how they wanted to. No one ever questioned it. We could do phone, we could do any number of things. And so I'll tell you that I had a beautiful script that I read every time before a hearing, that I was having these remote proceedings pursuant to the emergency orders of the Supreme Court and the orders of the OCA. And I stopped doing that a few months ago because I thought the suggestion that I could only do it because of the emergency orders or the guidance of OCA was incorrect. Because I could always have done it. I always had that power, and no one was going to question it, except then we had these orders suggesting that I had to have permission. So I think that we ought to also protect the judge's ability to decide in what proceedings remote options would be available, and it wouldn't be in every case. And I'm one of those judges, and I've told lawyers, and I'm not interested in having Zoom trials. Having said that, the folks who've actually done it, just like all these anecdotes about jurors vaping and being on the elliptical, the anecdotal information on the other side is that you have a more diverse jury pool. That mom with 2 kids isn't going to be a juror in your in-person trial because they can't do it, but you can get them virtual. You can get older people, you can get more diverse jurors. It's all anecdotal, not enough information is available, but pros and cons are available on both sides. And I think the access to justice question is important for us to address. And I also think that ought to be part of the intro. When we think we want to have in-person hearings whenever possible, we also want to make sure that we are addressing access to justice. Those are important things as a body that we ought to promote. And what I saw in these rules is not you should do this and everybody should do it, but if you're going to do it, here are the rules for providing notice. Here are the rules for how you subpoena. Here, that's the stuff I saw in the rules. So anyways, we can all go on and on. Thanks.
Thanks, Judge. Marcia Greer.
So I just wanted to speak to the access to justice piece because and maybe what we need to do is think about treating trials a little differently. I mean, that seems to be where the real issue is. But in the CPS cases, which are so important, I'm hearing from judges and court administrators that participation by all of the parties has gone way up in those cases, which I think is really important. Parents who may lose their kids or are trying to get them back, the CASA workers that are not getting paid, all the people who need to be there are able to show up. Teachers, people are able to participate and really be beneficial to the child's progress, and these hearings aren't having to get continued. They actually take place because the parent can step out of work and get on a Zoom call. And so I think that there's a lot that we need to keep. And again, we have to be careful about, to Judge Miskell's comment, not throwing babies out with bathwater, but also just the importance of the incredible increase of access to justice. Like you all, I am a baby boomer, technically, like to think I'm a millennial. I love being in the courtroom. It's not the same being on Zoom. I get it. But I also appreciate the value that it brings. And I want to make sure that we keep that in mind and come up with rules to make it work. None of us really thought we could go to this place 2 years ago, and we've adapted fairly well. And I think there are ways to do it. And it may be just learning some of the tricks. Like I know when we first started having Zoom depositions, people were like, oh, this is great. I'll sit in the room with my client and coach them. And so then, you have to figure out how to avoid that. And so there are ways to work around some of those issues of attentiveness, et cetera. And we just need to be creative. But I really want to make sure we don't focus solely on the trials and lose the benefit for everything else. And maybe if there is some serious concern about the Zoom trials, especially, I think bench trials can be done by Zoom. We've been doing evidentiary hearings and bench trials, the same thing. It's really the jury issue, and I've been doing a lot of work with the ABA on this as well. So I would include the ABA resources in the guide of looking at this. But let's think about the jury trials in a little bit different category about how that can best be done and not lose the value of virtual appearances for everything else.
Great, thank you, Marcy. Roger.
Well, I feel like by now I'm just going to be an echo.
You need to turn up the volume, Roger.
Second.
Can't hear.
We can't hear you.
I was going to say, by now I feel like I'm just going to be an echo, but I favor that we do kind of stepwise progression. That is, moving from what proceedings remotes will be available for or not, and then which ones it's going to be mandatory or not. And I have a couple of reasons for saying that. In the past 2 years, I think courts across the state have been dragged literally into upgrading their hardware and their software so they can do this. I'm surprised at the number of rural counties I go to where they can at least figure out in some way to do something on Zoom. And I will also say that just as 20 years ago or so, the attorneys fresh out of law school were all eager to drag us into the era of audio visuals in the courtroom. I think soon we will have a whole crop of new young lawyers waiting to drag us into how you use Zoom to do what you used to do live. And it's produced some good things. For example, when people started finally figuring out how you do exhibits and show witnesses things on Zoom, they found out the best way to do that was not only through share screen, but by sending the exhibits to the court reporter in advance. And some courts I now see are asking, if you want to use an exhibit during a hearing, send it to the court reporter the day before. What a concept, sharing exhibits the day before the hearing. That said, as I think we've all learned in the past couple of years, Texas's infrastructure to support Wi-Fi, broadband, and all that, well, it's just not like the East Coast or the West Coast, folks. And I can tell you from experience, It's one thing when the lawyers show up because they're going to have the routers and the hardware and all that in their office so they can have a good connection with the court. Not so with ordinary people. If they have to step outside and get on their phone, maybe they're in an area that is not such good reception for their phone. And we have to be aware of that. The other thing of it is, I hate to say it, weather. I was on a Zoom hearing yesterday, and the folks in Dallas were fading in and out on the Zoom hearing because of the weather-related problems. Weathers affect all those wonderful cell towers and electricity. So, like I said, I think maybe we're getting there, but we're not there that the infrastructure exists throughout. Now, talking about a while ago about whether the larger and institutional clients like this or not. I think they're schizophrenic right now. When it comes to pretrial hearings, they love the fact that the lawyer doesn't charge them for the time to travel to the courthouse and wait in the courtroom for an hour to be called for a 5-minute hearing. They love that. And they think that's wonderful. On the other hand, when you talk about making them try the case virtually with either the lawyers not in the courtroom or the jurors not in the courtroom, they start sounding like Richard Munsinger.
Eloquent, right?
Yeah, yes, eloquent, passionate. But the thing of it is, as was said earlier by almost everybody, most of this is anecdotal. Whether these trials work well or don't work well, whether they're a travesty or whether they're the wave of the future, really depends on what happened in your last jury trial done remotely, or your partner's last remote trial. It's all anecdotal. But there's one more thing that troubles me, which is why I say maybe go slow and do it stepwise. And that's not how lawyers behave in remote proceedings, but how ordinary members of the public act in these things. I don't think I've seen a tendency when you have witnesses or parties show up, it's like, I'm not really in the courthouse, I'm on TV. And then they tend to act like they see people act on TV. And this really, I have seen people do the most disrespectful things to judges and attorneys in these Zoom hearings. And it's just, I really think it's because they don't think they're in court, or they're part of my daughter's generation, my youngest daughter's generation, that grew up thinking that what's online or on TV is an alternate universe. It's not the real world. And so when they are in the court, when they're online and they see this person in a robe and they see these men and women in suits and ties who call themselves lawyers, they think they're just characters in a story, and they treat them that way. And so I worry that maybe we need to kind of work this out a little longer until members of the public realize that just because you're talking to a cell phone does not mean you're not in court. And it also doesn't mean that if you curse the judge, some sheriff, some deputy won't come out and knock on your door. So anyway, get back to what I said. I urge that we maybe ought to work this out in steps rather than wholesale all at once. Thank you very much.
Thank you, Roger. And I just put on a cat face when I'm in hearings remotely. So that's my solution to it.
Yeah. You think that you laugh, but if the judge knew that that's what the witness was doing while they're appearing remotely, that although you all think you're just fine, he thinks he's looking at a panda face because he can do that with his phone. It might be a little disturbing.
Absolutely. Judge Miskell.
I think one of the most important things, and I'm sorry if I didn't say it well enough at the beginning, my personal preference, and I won't speak on behalf of the committee, but my personal preference is to take jury trials off the table. So nobody likes doing jury trials on Zoom. Like, judges don't want to, parties don't want to. It's such a small number of the things that we are capable of doing on Zoom. I'd be happy to make the rule explicitly say that petty jurors cannot appear remotely except by agreement. I have no problem with that. So, because 90% of the objections have to do with jury trials, and like realistically, I don't think anyone even wants to do jury trials on Zoom. So to shortcut the discussion on all of that, I would propose that we can just expressly say petty jurors cannot appear remotely without agreement. Totally fine with that. The second thing I would say is, in our work, what we wanted to do was we wanted to leave the decision with the people closest to the case, closest to the facts, the people who have the information. Like, is this a super complicated case where the parties aren't very tech savvy? Yeah, that may not be the best candidate for Zoom. Let's not do it that way. Is this a case where several of the witnesses are in India? Maybe that's the one where we want to let the witnesses testify by Zoom. So I think we strove to have sort of, as we would describe it, local control over the decision, the people closest to the case making the decision, because for certain case types, for example, inmates are participating a lot more. So previously, inmates would really never participate in their civil case because we would look at the file and say, did the inmate request to be bench warranted over? No? Okay, it's a default. And now with Zoom, most of the county's jails will let them be on Zoom. And so now inmates are participating in their divorce cases or their other civil cases. So that's a plus, right? And that may not affect the big firms and the people on this call, but like there's not an insignificant number of inmates that we deal with. Same CPS, right? I am keeping my CPS docket on Zoom forever because the parents actually participate. The foster parents participate. It is just such a wonderful step forward because previously our system was in excluding all these people who don't have cars. And now just because you don't have a car, you don't lose your kids, right? So I think that's wonderful. But you can't make a rule that parses it down to these case types and those case types. You have to leave it to the people closest to the case, such as the attorneys, such as the judge who's hearing that particular case. So I'm not disagreeing with any of the things that the wonderful lawyers on this call are saying. If it's a great case where in-person oration by a talented attorney is going to make a difference, everyone would enjoy watching that in person, right? But most of my cases, so I've done, for example, over 300 bench trials on Zoom because those are family law cases. Half those participants are pro se. The average length of those trials is an hour and a half or less per side. And so for an example, yesterday, I'm in the North Texas area, and yesterday our county government closed all of our county buildings because of ice, because no one can get on a road. But there was a divorce case that really wanted to go. So we switched over to Zoom and we were able to do our less than an hour per side divorce trial on Zoom yesterday, despite the fact that the county was closed due to ice. And if I had had to reset that trial, it would have been like June. So that was a great example of a good tool, right? So anyway, my two proposals are, number one, go ahead and make the rule expressly say petty jurors cannot appear by remotely without agreement. That's fine. And then number two, let's just remember that not all cases are the same. And so for some cases, everybody might be more than happy that we have Zoom as an option. And in other cases, that it might not be right for that case.
Thank you, Judge. Judge Evans.
The line that I drew personally and still do draw is that if there's going to be live testimony that's going to be disputed, then I prefer to do it in person and would only do it by agreement on Zoom. And even then, I might disagree because I want to be closer to the witness. Now, I don't know how you draw that into the rule, but quite frankly, I don't know any colleague that doesn't follow that rule right now. I want to add one other situation that is where this rule is needed. If you don't have a rule on remote hearings when the emergency is over, there's going to be a lot of gouging that goes on. At this point, I'd like to insert Richard's comments about the judges, except substitute the word lawyers on this call. But there's a lot of other lawyers that don't meet those comments, and you can test my credibility in Richard's later on. But here we go. 25% of the cases that were filed in my civil court in Tarrant County were from lawyers who officed in Tarrant County. Now, it's as far from Collin County to Tarrant County as it is to come drive up from Austin. The bar that handles civil cases travels all day long just to get in to these counties. So if it's only by agreement, believe me, Richard and Tom, you're going to be flying from Amarillo and El Paso on a nothing hearing all day long just to get there. That's not good. That costs money and it wastes time. Pretrial work in civil courts rarely involves disputed testimony. I agree, there does come up, but pretrial work is almost all by submission. I mean, submitted evidence in advance attached to pleadings. And yes, there are times when you'd like to have argument in person. And certainly I agree with Judge Miskell about that. But for the most part, the only time you really need lawyers in pretrial work together in a courtroom is when they can't work out a discovery dispute and you have to put them in a room together to make them work on something. Now, I just give you that idea. So I don't know how you draw a rule around that or not. The other thing is there's another area besides CPS. Zoom hearings apply to child support work by the Title 4D judges. If you force a wage earner to spend all day waiting to get a hearing, and obligor and obligee, as they like to say, you just take two people that don't have any money anyway, and we have greater participation in child support right now, and we're moving our caseload all through this, and we haven't had complaints about not being able to do that in person. So it's not the same thing as a major dispute over expert discovery or perhaps a serious challenge on an expert witness, but you got to leave this in the hands of the judge to make a decision, at least on pretrial. And I don't have any problem with bench trials and or jury trials not being included in the rule. Now, finally, and please stop me, Chip, if I'm past the scope. I read the task force report and I thought it was great. I am concerned about the records custodian for these recordings. And I hope the court will, I know we're not discussing the specific rules, but if a judge decides they're going to record, then there has to be a standard that they're going to record all the hearings or they're going to delete all the hearings. There's got to be use restrictions not to use them for political purposes, because that's what's going on right now. They have some judges have their own private YouTube channel. They're off the platform of the OCA and they retain what they want and don't retain other matters. It's a few, but they are out there. And finally, who, if they're going to be retained, who keeps them? The clerk or the reporter or the judge, and for how long? And of course, I'd like to see a policy that they're just deleted, because I think they're going to be exhibit number one in every recusal hearing I'll ever see in the future once somebody starts recording. Because that'll be the issue. We've always replied, I know you've written in the reporter's record, but the argument always is the demeanor changes the words. And maybe that's the way it should be. But that is my concern. And I know you made an amendment to Rule 12, and you're going to say it's not a judicial record, but under Rule 12, it is a case record. And that's, those two sites are the opinion 003 and 004. So sorry I didn't email that earlier, but that does concern me. That's all my comments.
Great, thank you, Judge. Kennan?
A few thoughts. First, I want to echo what Judge Miskell said about the focus being on discretion, if you will, being given to the people who are closest to the case and who can assess what is and is not available in terms of technology and otherwise. And so I think there is value to giving the trial courts discretion as the judges are sharing. They each have their individual experiences with remote proceedings and have conducted many remote proceedings successfully during the pandemic. I don't think we should characterize all the data collected, all the statements as simply anecdotal and brush it away. I do think that there were some efforts by the Office of Court Administration to gather actual data about remote proceedings. And I seem to recall there being some statements, Chief Justice Heck, that you've made before about remote trials occurring. And so I believe there is data. Of course, it's always good to have more data, but I don't know when and it's time to say we have enough data. Let's make this remote option something that we address formally in the rules. In terms of what Judge Miskell said, I just want to echo too that speaking for myself individually, not for the subcommittee, the combined team, or the remote proceedings task force, I too have no problem treating jury trials differently. The task that we were given is remove impediments to remote proceedings, and that's what we did. But jury trials are different from bench trials and different from other proceedings. And I think in terms of just what I'm hearing in the legal community, the greatest resistance to change is in relation to the jury trials. So I think there's value with this committee, perhaps the subcommittee level first, looking at whether jury trials should be approached differently. I also just want to share that my own experience as a litigator during the pandemic has been that my clients have saved a lot of money because of remote proceedings and because of remote depositions, because of Zoom. And so I have seen and lived firsthand client savings that are significant because we can do things remotely. And I have heard from people who are in the trenches, boots on the ground, that people who could not participate at all in court proceedings have been able to participate. And I don't think that should be minimized. I don't think we should ever forget about the people who can't go and sit in a courtroom for hours waiting for their case to be heard, or that we should ever forget about the people who simply cannot take off time at all because they have to work 2-3 jobs in order to get by. These are people who don't have access to our court system if the only way they can get there is in person. And so while I appreciate completely the concerns about mandating the remote proceedings, I too have Fortune 500 clients, very sophisticated clients who, for some cases, don't want to be remote. But I also represent people pro bono. And the only way they can go to some proceedings is remotely. And I don't want to minimize that or lose sight of it in these conversations. And I don't want us to underestimate the fear of the resistance to change that we're all going to feel. And for the people who say you can never do this, it's crazy to think you could. I would say, well, it has been done. So it's not crazy to think that you could have even jury trials conducted remotely. I think we have seen many successful examples of it. With that, I'll stop. I'm certainly not trying to advocate aggressively for any of the remote proceedings proposals. This is just one option. I think that more data and more discussion will be good.
Great, thank you, Kennan. Richard Orsinger.
Thank you, Chip. In my view of this, our choices that we're asked to make recommendations on fall into 4 categories. So I'm going to talk about them as separate categories. One is by the consent of all the parties. And I wouldn't be surprised if there's not unanimity on this committee when we get to a vote, that if the parties consent, they should be allowed to have a hearing or a witness or a trial remotely. To me, the tough question is, if the parties agree they want a remote trial, can the judge force a live trial? Can the judge override the party's agreement? Or if the judge has ordered that it's going to be a remote trial, can the parties going to be a live trial? Can the parties override the judge? In other words, if there's consent of the parties, can the judge override the consent? Can the consenting parties override the judge? That's, I think, an issue we need to discuss. The second issue is witnesses testifying remotely. Now, what is the difference between a witness testifying remotely on a screen and a video deposition of the witness testifying remotely in the past on a screen? It's the same thing. It's a functional equivalent, except that you're probably going to get a better direct and cross-examination to have the witness testifying remotely live than if you have the witness testifying remotely by deposition taken before the trial starts. So again, I would expect that we'll probably could have a lot of agreement on the category of witnesses testifying remotely as a substitute for live. The third category is pretrial versus trial. And there's a lot more complication to trying a case on the merits than there is to having a pretrial hearing. And my experience has been like Kennan's and many others, that it has incredibly reduced the cost of litigation to be able to conduct pretrial hearings remotely. It not only eliminates the travel time, and it not only eliminates some of the waiting time, but I've talked to lawyers who have dockets that make them go to the rural counties surrounding the urban centers, and they save days, half days or entire days by being able to have remote hearings instead of getting in their car and driving 35 to 60 miles just in order to have a hearing. With regard to trials, you have non-jury trials and you have jury trials. The non-jury trial is much more amenable to remote access because you don't have to contend with all of the jury selection process and with the jurors. And then the question becomes, can a trial judge require that it be in person, or can a trial judge require that it be remote? In any event, I think that a non-jury trial is probably got more support for us to allow the judge to force it or to allow the parties to override the judge's requirement of being in person than if it's a jury trial. Now then, I've had the opportunity to conduct some video interviews for the San Antonio chapter of the American Board of Trial Advocates, and the first series we did was on Zoom jury trials. And I had about a 30-minute interview with the chief jury clerk of Bexar County. And the surprising thing to me now is what Kennan has been repeatedly saying, is that there's been tremendously increased participation by members of the community in the Zoom jury trials that never showed up for the in-person jury trials. So that's an important factor for us to think about. But again, probably the thing that would be most resisted is to force remote jury trials on a judge that doesn't want it or on a party that doesn't want it. So in my view, there's no question remote can reduce costs of litigation and increase participation. And to me, the dynamic here is, can you force something on an unwilling party? Can a judge force something on two parties that agree but differ from the judge? And can the parties force themselves on the judge? To me, those are questions we need to discuss still. Thanks.
Thanks, Richard. Jim Perdue. Jim, would you turn your camera off for a second? This is Jim Perdue before COVID. Now you can put it back on, Jim. This is Jim Perdue after COVID. Now you may go ahead.
It's been a very, very long 2 years. So since there's been some suggestion that the old guys are the ones that are having all the objection, and then I'd grow this beard out to age myself and put myself in the Riney camp, even though I am officially Gen X, not millennial. Although I only can aspire to be Tom Gregg. I was going to ask a question, Kennan, Did the subcommittee look at language to address excluding jury trials, or at least getting language that would, as Richard just mentioned, having the jury trial portion of what is considered a proceeding to be only by agreement?
I don't recall having that precise discussion, though there was conversation about jury trials and how they are different from hearings, but we didn't put pen to paper to try to draft out provisions to address jury trials and require agreement on that front. Judge Miskell, do you have any recollection?
I recall that we
Mine?
did not anticipate applying this to jury trials, and that everybody realized that jury trials would be the huge sticking point, and none of us are trying to force Zoom jury trials on anyone. And so I think I can speak for the subcommittee, at least on that part. No part of the subcommittee's work involved us thinking we're forcing jury trials on anyone by remote appearance.
I think the problem, and I think Kenan conceded it both when she laid it out and in the chat, is that the language in this new 21D doesn't make that clear. And in addition, you've got this new G for the municipal, for the JP courts, that clarifies that court proceeding includes trial. And you can easily see how that could be grafted on, because this concept of court proceeding, this language, which is replacing the term hearing, that you're deleting the word hearing and you're calling it a court proceeding. And then in another change, you're clarifying for the JP rules that a court proceeding is a trial, is going to cause a lot of consternation amongst the bar. And regardless of age, I suggest that is a real problem.
One of the, and sorry not to interrupt, but one of the things we did talk about is definition. So in family law, people call things final hearings. We'll have a final hearing on your protective order. We'll have a final hearing on your custody modification. Okay, those are trials. Certain of them are not allowed to be in front of a jury. So that's why we tried to work with the word proceeding, because when we got right down to it, people were not real clear on what is a hearing and what is a trial. But I'm fine again excluding petty jurors from appearing remotely. What I don't want to exclude is, can a witness testify by telephone in a jury trial? Have been able to for 100 years. I don't think we're meaning to repeal that with this one, but I'm sorry to interrupt. Please keep going.
No, I appreciate that, Judge. But I mean, so for the senator to pick up the phone and call Chip before this, having spent a little bit of time in Austin this past year, I want to share with the committee something that's sometimes flippantly kind of joked at, and I know Chip is never flippant, but you're taking the notice rule, Rule 21, and a thing that addressed filings and notice of hearings, and creating a new rule that is a massive substantive change to the law that is unavoidably in conflict with the terms of the government code. The government code being a creation of the Texas legislature that says courts shall sit in the county seat of the county in which it's created, and Chapter 24 of the government code, which creates all the district courts of the state of Texas, which I think the legislature appropriately is somewhat proprietary of. And you are eviscerating the idea of jurisdiction or presence in the community of those courts by saying that everything becomes a computer screen. And I do not pretend at all to speak for Senator Hughes or any other member, but the history here is there was language that OCA brought to the legislature in 2021 to try to do this. And it was not only rejected, but there was then language in the omnibus court bill that would have prohibited doing contested evidentiary hearings or jury trials without agreement of the parties. That language did not get over the finish line in the final omnibus bill. because there was a little bit of conflict between the Senate and the House on bail and some other issues, and it was collateral damage. But I don't think it's smart for this committee to be dismissive of the legislature's concerns that either this committee or the court via rule is going to substantively veto the clear language of the government code regarding where court proceedings are conducted and how. And this rule would do that. I noticed in the appellate rule, you basically have a provision in the appellate rule that stands in conflict to the 22-200 series regarding the courts of appeals. And then in the third section of the rule, and this may underscore somebody like Mr. Levy's concern, underlying all of this, that is that you have a remote appearance, and I don't, again, pretend to speak for the plaintiff's bar, and I certainly would love to hear from my colleagues and friends on the other side. You've got a proposal to essentially eviscerate the jurisdictional realm of subpoena power so that you have a statewide subpoena to get people to appear. That is a big substantive change, one that I perhaps as a plaintiff's lawyer might welcome, but there might be some people that have some pretty big concerns about that. So I would tell the whole committee that the legislative concerns that are behind some of this are going to be very real. And if the committee thinks that it can go down this road to essentially eliminate the presence of courts in the jurisdictions to which they are supposed to be accountable to the voters via the government code, this will get visited. So I don't think that the resolution of the state bar was contemplating that this was a conversation about jury trials, but rather a lowering the barrier, which is primarily a cost saver for all parties, and all parties, I think, on both sides of the bar in favor of cost saving. But not all of us have the credibility of Jackson Walker and Rusty Hardin at the Texas Supreme Court when a court is trying to force down a jury trial via remotely to get that decision eviscerated. So you, by creating this 21D under the language that has been brought to this whole committee from the subcommittee, recognize that according to A and B, as Robert Levy said appropriately, you are creating a rule that by default puts the court in total control of forcing the parties to have either the proceeding or the witnesses remotely. That is a sea change to practice, not necessarily bad in some proceedings, perhaps bad in others, but it will create some legislative scrutiny for doing it, given the way our system of judges works and the jurisdictional parameters of the individual district courts in the state. So I just wanted to kind of second Mr. Riney's point regarding jury trials, but on a bigger basis, understand that this 21D is, from my perspective, extremely substantive. And it stands as a substantive change in the law in contrast to the legislative action of the state of Texas. And so when you talk about local control, and I trust Robert Evans for local control, but there are instances where local governments, whether it be camping or police, are not given local control. So justices, judges in different jurisdictions may view their authority under this rule differently. And without a little more guidance regarding the objection, or as Richard, I thought, brilliantly laid out, a construct of breaking down the different areas where you have parties agreeing to certain things, different classifications. If you go down this road in 21D, which is an odd place to put such a massive substantive change, in my opinion, I think that it would be worthwhile to spend a little more time with all constituencies in the bar to consider how there could be a little more guidance so that everybody knows the ground we stand on, and consideration of the way the government code works and the empowerment of our district courts, JP courts, and courts of appeals.
Thanks very much, Jim. Judge Schaefer, were you waving to jump the line? Okay, then John Kim is next.
Thank you, Chip. So currently I'm the 2022 president of the National Foundation for the American Board of Trial Advocates, which is an organization of about 7,600 trial lawyers across the country by invite only. And I think that our working group with respect to this has mirrored some of the discussion that we've heard today. But I want to start by saying that, I believe in that old adage that bad facts make bad law. And just as in this circumstance, I'm concerned that we're letting an exceptional circumstance, this pandemic, drive wholesale substantive changes that will affect the Seventh Amendment and the ability to have been given the responsibility of judging the facts and the credibility, the opportunity to do so. Those comments saying taking jury trials off the table, but I think the problem is more broad than that, because I think it affects bench trials and I think it affects evidentiary hearings. And as an aside, let me say that I think that Zoom and remote proceedings by consent are remarkably effective for the vast majority of pretrial issues that we have, and it increases the access to justice. But when you get down to the fact-finding and the resolution of it, the credibility of the presentation is so much more important. And I would submit that it is impossible to properly judge the credibility of a witness unless it's in person. It is impossible for a court in a bench proceeding to properly judge the credibility of a witness unless they can see the totality of that person in person. Because as you look across the screen right now, you don't know who's nervous, who's twitching. You don't see the whole person and the body language, which goes, as scientists have told us, there's a whole body of science that tells us that is equally part of the credibility test or the persuasiveness test, or frankly, the ability to properly and rightfully advocate as you wish on behalf of your client. I'm also concerned that we're letting, look, this is an august group. I have tremendous respect for all the names and the people on this group, but we don't represent the majority of the bar or the practitioners and out there. And I would submit that to some extent, we're allowing an academic or theoretical discussion kind of put a cover on reality, because I work both sides of the bar. I represent the disenfranchised as well as Fortune 50 companies. But the reality of what's happening out there is gamesmanship. And so for if we were taking depositions or something against each other, there would be no problem. But the system is fraught with misconduct. There is witness tampering, there is witness coaching, there is obfuscation. I was in a deposition the other day where we caught them putting up an imposter for deposition that you couldn't tell because of the Zoom process, all sorts of identifying traits that would have made it helpful. You have people doing Zoom depositions in which the lawyer for the deponent is across from the camera where he can't be seen, who has flashcards putting up the answers that the witness should talk about. And that's just something that doesn't occur when you're talking about an in-person proceeding. I would also submit that civility decreases. the more and more you utilize Zoom, because it's just like the telephone. It's just like when we tell our kids, pick up the phone, call somebody instead of text somebody. You won't be as bold or brash or speak out of turn. Same thing with respect to Zoom. The filter and the respect and the dignity that that courtroom demands is diminished with respect to that. If we don't really assess the importance of credibility in an in-person proceeding, then picture this. You will have circumstances where you will never see the bad witnesses again. They're going to disappear, and you had your chance at deposition, or they'll appear by Zoom, and it's just not the same and just not as effective when you know I have a bad person. I would submit that it is not the same to put a video deposition up, because it affects strategy. Because so many of us know, especially in the larger commercial cases, your depositions are not trial depositions. And you don't want to take a trial deposition because you don't want to give up your trial position at that point in time. But many of those depositions by video are setups in which you have them committing to take a position in which you will cross them and affect their credibility, one hopes, during an in-person proceeding or a fact finding in front of either the court or a jury. So the last thing I want to say with respect to that is, well, I'm not going to say it if we've all agreed that we're taking the jury off the table. So that's all I've got to say. Thank you.
John, thanks so much. Judge Wallace.
Thank you, Chip. I want to address something Richard Orsinger brought up. One of his first comments was, if the parties consent to remote hearings, should the judge have the authority or the discretion to say, no, we're going to do it in person? There are some very few limited circumstances, but I think the judge ought to retain that ability to do that, because there may be something about the case that the judge wants to hear in person, either the lawyers or, first of all, to me, there's a pretty bright litmus test as to when a Zoom hearing is appropriate and when it's not. If it's an evidentiary hearing, I'd like to do it in court. If it's non-evidentiary hearing, then probably Zoom's okay. But one thing that I have noticed during the Zoom hearings, even though I've been sitting as a visiting judge by assignment, I've been doing it a lot. I see more discovery disputes than I used to. And the reason is pretty simple, really. Why spend an hour or two talking to an opposing law? This is not everyone does this, but there are a few. And rather than having to drive from Dallas or wherever to Tarrant County, let's just have a quick Zoom hearing and let the judge decide it. And I think that is a flip side and a disadvantage to these hearings being more cost effective. I agree with that. They certainly are. But it also sometimes, I think, encourages lawyers to be a little bit lazy and try to not even try to work out a compromise or an agreement before they put it on the judge's lap. So I would advocate for whatever rule we have, leave the judge with all the discretion to decide whether it's going to be in person or not, because I think they're in the best position to decide this. There's never going to be a one size fits all situation. That's all I had. Oh, and let me say this also. Another kind of axe I have to grind is minor prove-ups. In situations where there's a settlement involving a minor, and my practice is only civil, those are atrocious sometimes, because you'll have the parent in one place on a cell phone, and you'll have the two lawyers on different places, and you'll have the ad litem another place, and almost
always they end up being a disaster and having to be reset when everybody can get their act together. So, if there's money involved and if there's enough money involved to take up the court's time with it, I kind of think more normally there's enough involved for them to come to the courthouse. And so you can see and hear the attorneys and the ad litem and the parent. That's all I have. Thank you.
Thank you very much, Judge. Judge Esteves.
Well, I just think that this change has been fabulous for the court system. I mean, it may have been driven by need in the pandemic, but the changes that have happened, there are some things we need to fix and we need to tweak, and but I don't think we should pretend like it never happened when we go back to normal, whatever our new normal will be. I will tell you, when Richard Orsinger was talking, I thought he read my mind. I was gone for 30 minutes, so hopefully I'm not saying anything or something was already addressed. But I was gone and I got 3 criminal jail pleas done in less time than it would have taken me to drive to the courthouse and drive back. I got all the pleas done. So not only did the jail not have to worry about any security issues by transporting them and didn't have to worry about the money, the defense attorney got to get off of mine and go to a different county in 3 minutes and do another plea for someone else. So the efficiency has been amazing. And when I told them I was in a meeting and I needed to, I was going to not do any chit-chatting, they asked if we could let you guys know that they wanted an increased capacity of being able to use Zoom or remote proceedings. And I let them know we're doing civil proceedings today, not criminal. So they were disappointed, but their comment was, well, we're the ones that are always in the courtroom. So I disagree that the credibility is hard to determine. I see you closer right now than I would if we were in person. Now, I love seeing you guys in person, but I see all of you. I see your facial expressions. I know more about you because I also see what you've chosen to use as your background. I see somebody walk behind you and I see how you address those people. I see so much more than I ever have seen before with these remote proceedings. And I totally respect the fact that there's cheating going on. I personally, I hear the voices coming and telling them that I don't know where they came from for the answers during these remote proceedings. So somebody may ask them a question and all of a sudden you hear a little whisper. And then they repeat it. And then you go, who's in the room? And you need to identify them. Who just gave you that answer? So we know that's going on. But at the same time, a lot of the time we can address whether or not those are significant questions. If the question was, did that happen Tuesday or Wednesday, and it really doesn't matter what day it happened, then are we dealing with a huge credibility issue? Usually the fact issues that we have, and sometimes assuming everybody's telling the truth, we still get to the same answer. I absolutely agree with everyone. We should not even try to force any type of jury trials to be remote. I haven't done one. I know that some of you may have participated in that. I don't necessarily feel comfortable starting it if I didn't need to. So unless something happens and that's the only way we can do a jury trial, I personally will not be going out just in order to have that experience at this time, unless I'm required to. I totally agree with Judge Wallace regarding retaining the ability on whether or not it's appropriate. I know there's judges that still do not even feel comfortable conducting remote proceedings, and I don't think that they should be forced into doing or conducting any type of remote hearing if they are not comfortable doing so. For whatever reason, whether that's the technology or a hearing inability or they don't feel like they can judge the credibility of the witnesses in the same way. So I would say that the judge would have the ultimate would be the ultimate decision maker. Before I got off for that short period of time, I was, and it may seem an odd question or someone else may have addressed it, but I wanted to ask Robert, because Robert had spoken just a few times, maybe 4 or 5 people before I got to go. But I wanted to know if he personally used video depositions in jury trials or bench trials. And if so, was his issue that he can't confront them personally as a lawyer, or is it how the jury sees it? So is it because he wants to have that opportunity with that witness to confront him and maybe surprise him that he doesn't feel like he can do if it was a live witness, but he could take care of that if it was a live deposition?
I have not had the experience in terms of my practice, but talking to my colleagues, the issues relate, there are a myriad of issues. One of them, frankly, is when you're presenting a witness, you want to be there with them and be able to have that dialogue and discussion. And it's in the remote proceeding issue, it's not always practical or feasible to do that. In fact, it might be a problem if you're sitting there with the witness instead of being on your own separate Zoom session. And part of this also relates to the parties and what they want to do. And as Jim Perdue was saying, why should this not be a choice of everyone? I have a choice if I want a jury trial or not, I can choose it, but why should I be forced into a dynamic that I don't prefer and be forced to go to remote proceeding if I don't think that's right for me or the issues or my client or the witnesses, all of the factors that are tied into that process. That's part of, I think, the resistance is we're being forced into a dynamic that we don't believe is necessarily the best way to achieve justice.
So just, have you used the video depositions in jury trials before?
Oh, I'm sorry, video depositions. Yes, I've done that. Yeah, absolutely.
And did you feel do you feel like the issue is that you don't get to confront the opposing witness? Because as far as your witness goes, you can decide where that witness is. I have lots of lawyers that bring them all in their office.
Right. Yeah, in terms of
that they put them in
the old days, yeah, I could bring in my witness, or I could, depending on, if state or federal, if I wanted them to testify, but in state court, yeah, I could choose to let the witness testify by deposition. Sometimes I would ask questions if it was my witness as a cross so that I could present that at trial. Sometimes I chose to bring them in live, and most of the time I would prefer to have them live. And as a party, when the other side had a witness, generally I'd prefer the opportunity to have them live, but sometimes I would prefer the video deposition because I was comfortable with their answers and I feel like I got good answers, and rather than impeaching them with that testimony, it's more effective just to let the prior testimony stand.
And another thing, Judge Miskell, I've done a lot of the in-camera that used to be just with our children when we're doing a custody case. And they seem to love Zoom. They feel more comfortable. They talk to me more. I think it's because they're used to technology more. I don't know if that's true, but when we're doing these family law temporary hearings and they ask to have us speak with the children, they may be at the school and they go to the counselor's office, and they didn't lose a whole day while I was listening to the testimony. And I've never had one say they were uncomfortable being on Zoom. I don't know if that's been your experience or not, but I think there's just so many good things about the remote proceedings. And I'm more concerned that we won't keep the good that has increased the value and the access to justice and will end up decreasing it at the end.
One of the, and I'm sorry to cut in line, but one of the wackier ideas that we kicked around in subcommittee and didn't really go seriously anywhere with it was, what if we put like a dollar value cap on it, like cases less than whatever don't require agreement? Because I think the bulk of the cases that this room seems to be concerned about are complex civil cases with big dollars. And the bulk of the places we've seen the vast improvement that we're all excited about are people that struggle and that don't have transportation and inmates and all these children. And I wish there were a way to confidently address both types.
Thank you, Judge. Judge Schaefer. Rusty, you're in line. You're behind Justice Christopher, Alex Albright, and then you. And Richard, before we get to you for your second round, we're going to take a break. Judge Schaefer.
Thank you. I guess y'all are probably tired of listening to all this by now. Is anybody still awake?
I think it's fascinating myself. I really do. I think it's great.
I'm going to try not to be repetitious. I agree with most of what Judge Miskell, Judge Wallace, Judge Evans, and Judge Estevez have said about having this as a discretionary thing and having Zoom or the remote proceedings as something in our quiver, so to speak, to be able to move cases along. It's been really helpful. I'm still doing most of my regular docket on Zoom. If you want an in-person hearing, all you gotta do is ask for it. People aren't asking for in-person hearings, and so it seems to be working well. I haven't given a single thought to a jury trial on Zoom. There's 86 trial courts, including the criminal courts in Harris County. 2 of them, 2 civil courts, have had Zoom trials, and only 1 of them is still doing it. I don't think that's going to be a real issue, at least not in my experience. It is a huge savings for the clients and the lawyers and the parties and so forth to be able to conduct some of these proceedings without having to spend 3 hours down at the courthouse. Or as Roy Ferguson in West Texas has said, people can call in and Zoom in and they don't have to travel across the country for a speeding ticket. So it's a very cost conscious and saves on resources. And I want to emphasize also, my colleagues have told me that more default judgments are not becoming default judgments because people show up who otherwise wouldn't show up for hearings. All the family court judges who have spoken have talked about the higher level of participation because people who would not otherwise be able to come downtown and skip work have been able to do that. I just think it's a good thing to have. It should be discretionary. The one area I would disagree with somebody that it should be an agreement amongst everyone. You know, I know y'all are going to be surprised by this, but sometimes there's gamesmanship between the lawyers. And Robert, I know you wouldn't do this, but I feel certain that there are people out here, even in Houston, that would make some Dallas lawyer come down to Houston for a hearing and not agree to conduct that hearing on Zoom. And I don't think that's right. Now, the other side of that coin is people will say, well, you've chosen is your business model to practice in Houston if you're from Dallas, or in Austin if you're from Fort Worth, and so forth. True, that is part of your business model. But be that as it may, if you can find a way to save the resources and not make litigation cost so much, I think it's a good thing. So I think what this committee has done is really good. I think it needs to be tweaked a little bit so that we do take the jury trial out of it, but I don't think there's any argument. Not one person on this call has said they wanted to do remote jury trials. How could you, after listening to Richard Munsinger's closing argument about an hour and a half ago? So with that, I pass this witness on back to you, Chip, and I thank you for the forum to discuss all these matters.
You bet, Judge. Thank you. And now to our favorite millennial, Justice Christopher.
Woo! I'm so glad to be in that category instead of baby boomer. as my children love to say, okay, boomer, whenever they don't agree with something that I have said. I have told them that's a microaggression though, and they need to stop. So, we're working our way through that. What I wanted to ask Jim was why he thought this rule ran into trouble with the government code. And if you want to just tell me later, that's fine. But is it because the judge is not in the courtroom holding the proceeding, or because they're, the idea behind it is we're not affecting the open courts. Everyone is going to see what's going on in the trial. So I was just a little concerned with your statement there on that. But if you want to talk to me about it later, that's fine.
No, I think it should be on the record, Judge, but maybe we could talk about it after the break. I'm worried that poor Carol's been going for 2 hours now. I wanted to get through our first round though, so.
Okay, could I just say one other thing to
Yeah,
Robert?
yeah, for sure.
We have had a lot of experience with remote trials and remote hearings. Maybe you haven't. Maybe the kind of cases that you work with have not. And again, what we can do with that respect, perhaps, as Judge Miskell said, okay, well, one of the things that we could put in our objection is that, the size or the complexity of the case requires in-person. There are ways to tweak it without just saying, oh no, we can't make any changes. Thank you.
Thanks, Judge. We'll come back around to you and Jim Perdue after the break, but Professor Albright, thanks for jumping back on. We need to hear what you have to say, which you only said in a chat.
Yes, that's what I was going to say. As I was asked to say this, I'd put it in the chat. I just wanted to go on the record as a proud baby boomer and 30-year veteran of this committee. So I now think I get to qualify myself as one of the old guys or maybe old girls. I think this is great work, and I think we need to work on the hard questions of it. I think having a discussion about whether we're going to allow remote proceedings or not, it reminds me of the discussion this committee had back in the 90s when we talked for hours about whether to allow fax service, because there were people who didn't like all that paper coming through a machine and they weren't sure their secretary would find it. And, it's just I think this committee tends to not want to adopt technology. I agree with what Judge Christopher just said. This is not like it's brand new technology that we haven't tried. We've done this for 2 years. We are here. People have used it for 2 years. They are not going back. You can tell from what the judges have said, the judges aren't going back. The people of Texas aren't going to go back because this is so much more efficient. There's so much more access to justice. There's more open courts because people can watch proceeding. I have watched hearings on the computer that I would never have gone down to the courthouse for. And I think that's important. So I think that helps our open courts as well. I think we do have some hard questions that we need to discuss and answer, like Richard and Judge Evans and other people, Jim Perdue and others have pointed out, and that's what we need to spend our time on. So I think it's important that we keep this going and have good rules in place so that we do it the right way. And I also think open court, I think that that provision about being in the county, I think that just applies to trials, but I'm happy to look at that as well.
Thanks very much, Alex. And now the last speaker before the break, another millennial, if you square it, Rusty Harden.
Well, once we make it an age factor, it puts some of us in a very small minority. So I regret that part of it. But look, everybody agrees that it's an advance to have some remote hearings. I think people like John and Jim and I and others, I missed some of Robert's comments, but because I have a jury trial scheduled Monday and I had meetings that I couldn't change for the earlier portion. I think that where a lot of us come down is compelled adversarial hearings. And if we're talking about, whether we're talking about a jury trial, whether we are talking about depositions, whether we are talking about any other type of proceeding. I've been in so many situations where the reaction in the actual courtroom to compared, or in the actual deposition compared to the reaction of others, is very, very different. There is something about the atmosphere of in-person proceedings that I think lend a whole different perspective. And a lot of it, some of you may know, I commit malpractice in multiple areas. So because we do both civil and criminal, and we get in the way of people in probate court as well as civil courts and criminal courts. And Monday's trial is a civil case. In other cases we've got going on right now, we're arguing about in-person, and we made it part of the agreed docket control order that the depositions had to be in person if the person chose. We didn't say it couldn't be remote if the two sides agree. But if I go back for just an example of what happens, and this happens in assessing the credibility, and I think we just cannot discount what John Kim is saying about credibility concern. For instance, it's just an informal poll. When Roger Clemens testified before Congress, he, on TV, looked like a horrible witness. 85% of the American public in polls, 90% thought he was lying. There was a whole different reaction within the very crowded hearing room. It was like maybe 50-50. People came down on both sides. And it's because the in-person experience and watching and listening and understanding the dynamics of what was going on was entirely different than the reaction of people watching it on TV. I've been sort of the throwdown opponent to cameras in the courtroom, not for appellate arguments, but for anything contested where you had witness and jurors exposed to Sarah, because I really do believe there's a different experience live in the person than there is before. I've got depositions going on right now where I know that the reaction would be entirely different of the witness remotely. We do remote depositions in certain circumstances. It depends how adversarial it is, or whether it's just information gathering. If it's information gathering, it's not such a bad experience to have remote proceedings. But I moan the loss of the way the system continues to pick proceedings for efficiency or cost that demeans and starts to lower the art of advocacy. And I truly believe that if we start making everything mandatory, I hear the tone is sort of, you take the jury out, just as Judge Schaefer just said, take the jury out, that's not going to be compelled. But when you compel other proceedings, you also undermine the ability of an advocate for the person. Doesn't matter whether it's criminal or civil. The advocacy and the ability to challenge what that witness is saying in such a way that calls into question perhaps what at first blush sounded very self-evident. And the same thing is true with the depositions. I hate to see us compel these proceedings. There are a lot of hearings. I've had hearings before Judge Schaefer where there was no evidence. It was the two sides arguing. That's a whole different thing. I can't imagine anybody's opposed to remote proceedings before trial judges over issues that do not involve witnesses in which they're going to be questioned adversarially. But once you move into the adversarial process with people, it's a whole different world. And I think it changes the nature of the trial. It changes the nature of the hearing. And I think it changes the nature of the truth-seeking process.
Okay, great. Rusty, thank you very much. We'll come back and tag Justice Christopher and Jim to finish off that Q&A. And then we'll go to Richard Orsinger and see what happens after that. So we'll be in recess until 3:20.